10 seconds to go. The Orissa High Court has held that the prosecution must examine the magistrate who conducts the test identification parade as a prosecution witness so as to ascertain the identity of any irregularity caused during such exercise. The four appellants were charged and prosecuted under Section 395 punishment for dacoity of the IPC for allegedly causing assault to the informant and forcibly robbing him of valuable articles. The police started investigation pursuant to the FIR filed by the informant, and during the course of such investigation, one of the appellants confessed his guilt and disclosed the names of other appellants who were involved in committing the offense. The trial court held the appellants guilty of the aforesaid offence, taking into account the fact that the robbed articles were recovered from their possession. Besides that, the court also gave due consideration to the identification made by the informant during the TIP. Appeal against the order of conviction was made, basing upon the ground that only four persons were involved in the offence and therefore the offence under Section 391, which is punishable under Section 395, is not made out as involvement of at least five persons, is a sine qua non for invoking the section. At the outset, the court noted that the informant has informed about involvement of only four persons in the crime. It also reproduced the charge had drawn by the trial court, wherein charge was framed against four persons under Section 395 of the IPC. The bench was of the considered opinion that without the involvement of at least five persons, charge under Section 395 could not have been framed, and thus held as follows: since one of the essential ingredients of the offence under Section 395 of the IPC is that five or more persons must have conjointly committed or attempted to commit robbery. The framing of charge against the four appellants under Section 395 of the IPC by the learned trial court, without any indication that they four, along with others, committed dacoity. The framing of charge, so also the conviction of the appellants under Section 395 of the IPC, is not sustainable in the eyes of law. From the examination in chief of the informant, it came to the light that he previously knew two of the appellants. However, despite knowing them, he did not mention their names in the FIR. The Punjab and Haryana High Court today sought response from the Union government and other authorities on plea challenging the alleged withholding of YouTube accounts of a trust and its journalist editor, allegedly for covering farmers' protest. As per the plea, the accounts were blocked on center's request, citing national security and public order concerns. The Supreme Court Constitution Bench resumed its third day of hearing the issue relating to the state's power to regulate and levy tax on industrial alcohol. The underlying issue is whether intoxicating liquor over which the states have power includes industrial alcohol. The union, in its opening arguments, countered the earlier contention of the appellants that the term liquor should be given the widest interpretation possible. As per the union, what is important is to understand simple terms like liquor from the perspective of the framers of the Constitution when interpreting different entries within the seventh schedule.